Hello, hello, hello. Hey, I just wanted to come on today, and we're going to get back to talk. We talked about this the other day. Get back to talking about Texas Court of Appeals. Talk about briefs. Talk about your oral arguments and things of that nature, which is what I prefer to do on this channel. But quickly, I just want to send out a prayers to the family of Tony L. Mathis. Um, he was very important in Sebastian Wayne Rogers' case, and very important to Seth Rogers. So, um, everyone, please be respectful to his family as they mourn his loss. And we'll stop at that. So anyway, let's get going on this case. Anyway. So today we're going to take a deep dive into the appeal of Jerry Don Elders. Now, this is a death penalty case in the state of Texas. Okay, this case, it raises serious questions about how justice is handled in the courts. We're not just talking about opinions. We're going to go straight to the source, the actual appeal brief, the legal arguments, and the courtroom proceedings themselves. Okay, this is how we're going to do. Now, this trial, the appeal and the briefs could include legal errors, constitutional violations, or issues with how evidence or testimony was handled. Tonight we're going to talk about, it's not tonight, it's actually today. We're going to walk through this. So let's talk about our fair use disclaimer. I like to go out and do that first. Let's just go ahead and get that talked about and over with. So this live stream is for educational and informational purposes only. I'll be reading from publicly available court documents and showing portions of a recorded court proceedings. All materials are used under fair use for purposes of commentary, criticism, and analysis. I am not providing legal advice. This is just a breakdown and discussion of a case based on public records, period. Okay? So we're going to start the case out with, I'm going to show you some of the news stories from when this case originally happened, and then we're going to move into talking about the brief that was filed by both the defendant and the state, and then we're going to show the oral arguments as they discuss what they think went wrong. Okay, why the defendant thinks he deserves a new trial. So with that being said, let's just go on over here, and we're going to start with this right here. Let me share my screen. All right, hang on just a second. All right, now put this on up here, and all right, hang on a second. Oh, Steve, I didn't share my screen, did I? Oh, stomach. Silly. All right, let's go ahead and get that. I forgot which one. Here, I'll use this one. All right, right here. So we're going to start with this one right here. Okay. And there it is. Now, let me make this a little different looking. So, a Johnson County man convicted of capital murder for shooting and killing. Whoops, I don't want that one. Not that one. Okay, we're back over here. Of shooting and killing a North Texas woman during a carjacking in 2021 was sentenced to death Thursday, officials confirmed. Now, this is back in May and April of 2024. The Johnson County jury found Jerry Don Elders guilty of capital murder on April 25th, and the sentencing phase of the trial concluded that Thursday of this was in 2024. He faced either the death penalty or life in prison without the possibility of parole. And Elders was arrested in Gainesville on April 14th in 2021 after 14 hours long search. Now, hang on a second. I need to do something real quick to protect our channel. We don't want to get, those nasty copyrights. So let's kind of put our little dots over it if we can. There we go. All right, now we'll continue this now. So, police said Elders first shot and injured a Burleson officer, Joshua Lott, during a traffic stop, and Elders, who was with two other passengers, left the scene. Police said the trio then abandoned the vehicle. Elders later shot Robin Waddell during a carjacking at a home at the 8,000 block of Road 802, police say. Police issued a blue alert for Elders, who was taken into custody hours later in Gainesville after they found him in a wood area following a chase into Interstate 35. Elders is facing either the death penalty or life in prison without the possibility of parole. Sentencing hearings will resume, and this was back in 2024. Now, we do realize that he was given capital punishment. So let's get back over here, and we're going to unshare the screen so we can put the next thing on that we want to talk about. Okay, so let me get this over here. So I'm going to pull up the brief from the Texas Court of Appeals. I kind of got this already over here, so we can talk about that for a second. Now, let me do this. Hang on just a second. Let me see. Summary of. Hang on. Bear with me. Let me pull this up. All right, I'll pull this up over here because we have the brief. Okay. Okay, where are we? That one. Okay. Now, let me get his brief over here. Go to the briefs because I forgot it's on my phone. It's not over here. No, it's over here. Let me pull this up from hang on, let me close it. Oh, not that. Okay, I'm gonna close these out. I'm gonna leave that one up. All right, I'm gonna go pull the briefs that I've already got saved on my computer so we can just read them aloud. So hold on just a second, bear with me. I forgot to save them over here. I know, so silly. But anyway, okay. Come on, pull up. Oh. Let's go see. Jerry Elders. Hold on, let me pull this up. Ding, ding, it's thinking, it's thinking. Come on now, computer. I just put this on here. Okay. I'm going to start with okay, here's one of them. All right, now I'm going to have to share my screen so you can all see what I'm looking at over here. And there it is. Now, let's see. Oh, come on, share the screen, silly girl. Share the screen. And it is Jerry Don Elders. Now, this was filed on 2026, February the 10th. Okay, and to the clerk of the court for Jerry Don Elders versus the state of Texas. All right, so they were going to have oral arguments are requested, and they were granted. We're going to see the oral arguments in here in a little bit. So let's start talking about what happened in this case and why they think they deserve a new trial. So, we're going to start with, here we go, appellate issues in number 1 through 3. So, appellate questions were vague, overly broad, and constituted improper commitment questions. And it starts about the summary. Appellate questions, that's where it starts talking about that. And then the reply to their questions is, the state's arguments was proper response to appellate's claims, and any potential harm was cured by the court's instructions and was harmless. So that's the state's discussion on this. We're going to start reading it right now. Here we go. Let's go on down. We don't need to name the parties of the attorneys, etc. We're not going to do that. We're just going to go down to what actually happened in this case and why he thinks he deserved a new trial. So, get on down. Statement of facts is where we're going to start. So, making sure everybody can see what I'm seeing. All right, so here we go. Ready? I mean, it's a lot of reading, but it's I can take the dots off now that we're not showing somebody else's work or showing another channel, etc. So let's get going on this. Let me see if I can make it bigger for you. I think I can. Let's see. Hang on. Where's the little dilly here? No. Okay. In the early morning hours of April 14th, 2021, appellate, which is Elders, and his girlfriend picked up Jerry Brewer from a friend's home in appellate's maroon Mazda. It was a Mazda Tribute, which is a type of a car. At 4:06 a.m., while the appellate was driving behind Burleson High School, Burleson Police Department officer Joshua Lott started a traffic stop after observing defective driver's brake lights on the appellate's vehicle. Officer Lott exited his patrol vehicle and approached the Mazda from the passenger side. He observed the appellant in the driver's seat, Brewer in the back seat, and appellant's girlfriend in the front passenger seat. Officer Lott noticed the appellant repeatedly looking into his rearview mirror and out the windows, seeming very nervous. Brewer heard the appellant state, "I'm going to shoot him." Okay, you can imagine right there at that point when the officer thinks he hears the person say, "I'm going to shoot him," the fear that's running through his mind, in this officer's mind, and I understand. I mean, I would be afraid too if somebody said that. So this is the gist of how this started. This is how the whole thing started. Officer Lott knocked on the passenger side window 3 times. The appellant shot Officer Lott 3 times. Officer Lott retreated to his patrol vehicle for cover and contacted law enforcement dispatch for help as the appellant fled in the scene in his vehicle. So he shot the officer. The officer managed to get back to his police patrol unit and ask for help. Now we know he did not survive because this is what the case is about. Appellant kept driving through Burleson until his vehicle caught fire near the Burleson Animal Shelter. The appellant pulled the vehicle into a ditch and the occupant fled on foot. A passerby observed the vehicle on fire and approached to check the occupants. The passerby removed several items from the rear cargo area, including the appellant's Social Security card and tax documents, making appellant the suspect in the shooting. So a good Samaritan thought he was going to do something good and try to help, and he did help because he was able to find out who the car belonged to. While the officers were still investigating the officer involved in the shooting, they received a report that a vehicle had rammed the gate on the Joshua Police Department and that a female was found unresponsive in the rear parking area. At that time, the Joshua incident and the officer-involved shooting were not believed to be related. Joshua Simmons, a Joshua Public Works employee, reported hearing a loud screeching noise and seeing a small silver truck crash through the gate. Simmons observed a white female, later identified as Robin Waddell, exit from the driver's rear area of the vehicle and run toward the rear entrance of the police department. Oh my gosh, the poor thing was shot and she was running. Okay, so she's been injured, shot by the same person, and she's going to go. She takes herself to the police department, trying to run into the police department to get help. This is very sad. Trigger warning. I'm so sorry, trigger warnings. Simmons then heard the distinctive pop. When Simmons reached that area, he found Waddell lying on the back steps of the police department while the truck drove away. He drove away in her vehicle. Emergency medical services responded and found Waddell in a bloody shirt and without a pulse. Waddell had suffered gunshot wounds to her shoulder, her right arm, and her chest. Medical staff connected a cardiac monitor, which showed no electrical activity. CPR was started, and Waddell was transported by ambulance to the Texas Hughley Hospital. Despite continued medical intervention, Waddell was pronounced deceased at 9:30 a.m. Okay. Around this time, law enforcement was notified of a burglary of a recreational vehicle in Joshua. A card bearing the appellant's name was found at that scene. Law enforcement investigated Waddell's home, and it was reported that her silver Toyota Tacoma was missing. The license plate number for that truck was entered into a license plate reader system, where it was later captured in Denton County on Interstate 35, headed northbound. Well, how about that? Okay, so think about that. Now, that's the one thing I did not realize about license plate readers. They put the license plate in there, and then automatically it goes out, and every license plate reader starts looking for this, and they find people. That's very interesting. I did not know that's how it worked. That's great. What a wonderful tool. See, I learn something every day. All right, let's keep reading. About 1:30 p.m., the Gainesville Police Department received information that a wanted subject was in the area. Appellant, which was Mr. Elders, was apprehended on foot in Gainesville after being found hiding in the brush line near a middle school and an adjacent soccer field. Oh my God. So now he's over by a middle school. That's so dangerous. What if he would have, oh, we don't want to talk about what ifs. Waddell's vehicle was located abandoned at the creek nearby. During the search of the vehicle, officers recovered the revolver used to shoot Waddell under the front driver's seat. A shotgun stolen from the recreational vehicle and Joshua was found in the back seat. The revolver and parts of the vehicle's interior were swabbed for DNA. Around 4 p.m., Texas Ranger Don Stoner responded to the Cook County Jail, where he met the appellant. During this custodial interview, appellant admitted he forced Waddell to drive, shot her, and that in a response to a question about the shooting of Officer Lott, stated that he did not like police officers. Just because you don't like somebody, you have the right to shoot them? Dang. Okay, so, again, trigger warning in this, trigger warning. But I'm going to tell you, this guy already sounds like he is absolutely a sociopath. A subsequent search warrant was executed to obtain appellant's DNA, which matched the DNA recovered from the revolver and the interior of the vehicle. Now, conditional requests for oral arguments. This issue discussed in this brief are well settled. An oral argument would not aid this court's decisional process. The state's request, however, that it be allowed to appear and respond to any oral argument presented by the appellant. And we know there was an oral argument granted because we're going to watch it here in a few minutes. In his first three issues, appellant contends the trial court abused its discretion by prohibiting him from asking three questions of the Barron members, Jeffrey McGee. Appellant asserts he was prevented from inquiring into McGee's views regarding the proper punishment for individuals who shoot police officers, his general opinion about police officer shootings, and his opinions about a specific Burleson police officer shot in April of 2021. The state of Texas respectfully disagrees, and due to the similarity of these issues, wishes to combine its response. So here's the issues presented. We're going to start with A. Does a trial court abuse its discretion by prohibiting the defendant from asking vague, overly broad, or improper commitment questions during a jury selection? That is the question. Summary of the argument. A trial court does not abuse its discretion by prohibiting a defendant from asking vague, overly broad, or improper commitment questions during a jury selection. Here, appellant was barred from questioning the members, McGee, the member of the jury, or in the voir dire process, from questioning Mr. McGee about his views on what should happen to someone who shoots a police officer, his general opinion on police officer shootings, and what should happen to an individual who shot a police officer in Burleson, Texas, in April of 2021. The appellant's second question was vague, overly broad, and his first and third questions were vague and overly broad, and constituted an improper commitment questions. Therefore, the trial court acted with its discretion, prohibiting these impermissible questions. B. The standard of review. A trial court has broad discretion over the conduct of voir dires. As the Supreme Court has recognized, the judge has broad discretion in the manner it chooses to conduct voir dire, both as the topics that will be addressed and the form and the substance of the questions that will be employed to address them. The trial court has broad discretion to restrict voir dire questions that are confusing, misleading, vague and broad, or improper commitment of questions. Appellate courts review limitations on voir dire questioning under an abuse of discretion standards. Because jury selection involves practical judgment, it calls about efficiency, fairness, and considerable deference it afforded to the trial court's management of the process. A ruling restricting voir dire will be distributed only when the limitation or renders the defendant's trial fundamentally unfair. And we're going to go to see the relevant facts to this question. On February the 9th, 2024, the trial court conducted jury selection of your member, Jeffrey McGee. During voir dire, appellant tried to pose three questions to Mr. McGee, each of which drew an objection from the state. The trial court sustained objections to all three questions. Appellant asked, do you have any opinion on what you think should happen to someone that shoots a police officer? Do you have any opinion about police officer shootings? And based upon what you heard happen in Burleson to a certain unnamed police officer in April of 2021, have you formed any opinion or conclusion about what ought to happen to the person, anybody found guilty or found to have perpetrated that shooting? Those are the three questions. The relevant law. The rules governing jury selections are intended to ensure that criminal juries are fair and impartial to both sides. Voir dire serves several related purposes: to uncover information that would support a challenge for cause, to help with the intelligent exercise of preemptory challenges, and to establish a working rapport with prospective jurors. A question is proper if it tries to reveal the member's views on issues that apply to the case or otherwise helps expose potential biases or disqualifications. Now let's talk about this for just a second on disqualifications. If you remember, now we have a real big problem that Miss Letitia Stouch is getting a new trial because of a biased juror and that whole preemptory challenges and not removing that juror from the voir dire proceedings. And because even though he was an alternate, he ended up becoming part of the jury. So, part of the jury that made the decisions on her punishment, and it is prohibited. The oral arguments on her case were very, very interesting, and I really enjoyed watching them because it helps you understand when something is completely biased. And so I understand what's happening here and why they feel like this might be biased. Because if a person says automatically, if you shoot a police officer, you should get the death penalty, I mean, is that how Mr. McGee thinks? That's what they're trying to get to when they're asking these questions. Because a lot of people do absolutely feel like if you have shot a police officer and you knew they were a police officer, well, you should just get the death penalty. Okay, so we'll keep reading. Questions aimed at discovering grounds for a challenge for cause or helping counsel make guided preemptory strikes fall within legitimate scope of voir dire. At the same time, the trial court retains authority to prevent improper questioning. An otherwise relevant inquiry becomes impermissible if it tries to commit a juror to a particular verdict based on a specific or hypothetical fact. As courts have explained, an attorney cannot attempt to bind or commit prospective jurors to a verdict based on a hypothetical set of facts. Commitment questions may be yes or no questions, or open-ended inquiries that effectively ask a juror to predetermine how he or she would decide the case. Likewise, questions that are overly vague, broad, and amounting to a global fishing expedition may be limited. A venire member may be challenged for cause when, among other reasons, there is from hearsay or other sources such a fixed conclusion about the defendant's guilt or innocence, it would influence that juror's verdict. Okay. Now, this is E. Appellant's questions were vague, overly broad, and an attempt to improperly commit the member. Appellant contends the excluded voir dire questions were proper inquiries into potential biases or prejudices, and to the third question, an attempt to determine whether the member had formed a conclusion regarding the appellant's guilt or innocence. The trial court acted within its discretion because the challenge questions were vague, overly broad, and constituted improper commitment questions. First, the appellant's second question, whether the member had any opinion about police officer shootings, was impermissibly vague and broad. Because the trial court had the authority to prevent endless jury selection or global fishing expeditions, the trial court properly limited the appellant's vague and overly broad questions. Second, both the first and the third question were vague and improper commitment questions, asking that what the venire member thinks should happen to someone that shoots a police officer, and whether the venire member had formed an opinion about the proper punishment for someone found to have perpetuated a shooting of an unnamed officer in Burleson, Texas, asking the venire member to set the hypothetical parameter. The hypothetical parameters for future decision making. These questions sought to bind the jury to resolve punishment in a particular way. And I kind of agree with this. Appellant's attempt to characterize that third question as relevant to a challenge for cause regarding guilt or innocence is unpersuasive. Any opinion about a hypothetical police officer shooting is irrelevant as the appellant's guilt or innocence of committing murder during the commission of a robbery, because the proposed questions were vague, overly broad, and constituted improper commitment questions. The trial court reasonably limited the voir dire. Accordingly, the appellant's first three issues should be overruled. Now, this is going to be the reply to the appellant's issue number 4. In his fourth issue, appellant contends that the trial court abused its discretion by denying his request for a mistrial after the state allegedly commented on his failure to testify during the punishment phase of trial, and asserts that the trial court's curative instruction to disregard was ineffective. The state of Texas respectfully disagrees. So what they're saying is the Mr. Elders is upset because there was some statement made about his not wanting to testify, made him appear to look guilty, and then they gave curative instructions, which is disregard. I understand that too. The issues presented here. Does a prosecutor's closing argument impermissibly comment on a defendant's failure to testify in the argument? Is it a response to the defendant's closing argument? He uses that in his closing argument? Oh boy, to me that is bad. But it is twice cured by the court's instructions to disregard and results in no harm. Okay? That's what they think. I think it could cause harm. I do. I think it could cause it. Here we go. So a summary of the argument. The state's closing arguments during the punishment phase were proper and focused on the issues raised by the appellant and would not have been understood by the jury as a comment on the appellant's failure to testify. In other words, they're saying, well, they they may have heard that, but they were not really understanding what the prosecutor was saying about the defendant. Only the defendant's attorney did. So when considered in context, the challenged remarks directly responded to appellate's own closing argument and constituted a permissible reply to matters he placed before the jury. The court further ensured that the fairness of the proceedings by twice instructing the jury to disregard the state's arguments, which was enough to cure any potential prejudice. Still, if there was any error, it was harmless. B. The standard of review. When a trial court sustains an objection and instructs the jury to disregard the complaint of statement, but denies a motion for mistrial, the question on appeal is whether the court abused its discretion in refusing to grant the mistrial. The reviewing court considers the evidence in light most favorable to the ruling and evaluates only the arguments before the trial court at the time of its decision. A denial of mistrial must be upheld if it falls within the zone of reasonable disagreement. Okay, so let's talk about the zone of reasonable disagreement. Hang on a second. Okay, let's go ahead and talk about what is that. Why are they saying that? All right. So the zone of reasonable disagreement. Okay, what it means in plain English is the appellate court is not asking, was this the best decision? They're asking, was this decision so wrong that no reasonable judge would have made it? If the answer is no, then the ruling falls inside the zone of reasonable disagreement and the trial court's decision stands. How it affects this case, in a case like Jerry Elders, the judge should not have allowed certain evidence or the judge made an unfair ruling. But the appellate court may respond with, we might not agree, but reasonable judges could differ on this. So that would mean there would be no reversal because it wasn't outside of the zone, okay? So that's what that means. Now, in determining whether the standard has been met, courts consider three factors: the severity of the alleged misconduct, the curative measures taken by the court, and the strength of the evidence supporting the conviction without the complaint of conduct. Because the law presumes that jurors follow the court's instructions, curative instructions would ordinarily be enough to remedy any harm. Okay, so let's talk about that for a second. They are assuming, let's talk about how the law presumes, okay, hang on, law presumes that they're going to follow the court's instructions. Okay, hang on a second. Let's talk about the court's instructions for a moment. Here we go. Now, the law presumes that the jury followed the court's instructions. Now, this is a core appellate principle. You hear in opinions and briefs, it means the court assumes that jurors did what the judge told them to do, followed the legal instructions, applied the law to the law correctly, and ignored anything they were told to disregard. But do they really? That's a big question I have. Do they really ignore and disregard? That's a big question. It protects the finality of the verdicts. It avoids retrying a case based on speculation about what jurors might have thought. It puts the burden of the appellate to show actual harm, not just a possibility. And how it affects this appeal. The jury heard improper evidence and a statement was prejudicial. But the court responded with, the judge gave a limiting instruction or told the jury to disregard. We presume the jury followed the instruction. That's their presuming, it's presumptions. Unless there's strong proof otherwise, the issue usually does not lead to reversals. Okay, now, about that for a second. Because the law presumed that the jurors followed the court's instruction, curative instructions will ordinarily be enough so there won't be any harm. But C, the relevant facts. During the state's closing argument at the punishment phase, the state argued that the jurors haven't heard anything that excuses his behavior. Appellants objected, and the trial court overruled the objection. In his own closing argument, appellant emphasized that his status as drug addict did not excuse the appellant's behavior. Later, during the state's final closing argument, the state asserted that at no point during his trial has the appellant taken responsibility for his actions. Appellant again objected, and the trial court sustained the objection and twice orally instructed the jury to disregard the state's argument. D. Relevant to the law. The Fifth Amendment prohibits the state from commenting on defendants' decisions not to testify. In determining whether a prosecutor's jury argument violates that protection, a reviewing court must evaluate the challenged language from the jury's standpoint and resolve any ambiguity in favor of the finding of the argument that's permissible. A statement is an improper comment only if it was manifestly intended to highlight the defendant's failure to testify or was of such character that the jury would necessarily or naturally understand it as such. If the language can reasonably be construed as an implied or indirect allusion, no constitutional violation occurs. Courts examine the full context of the arguments to determine how typical jurors would have understood the statement. A reviewing court will not infer an improper comment when another plausible explanation of the remark exists. The implication of the prosecutors referred to the defendant's silence must be clear and necessary, not speculative. Also, remarks that are fair responses to the defensive arguments or that supported by evidence in the record do not violate the Fifth Amendment. Commencement was not related to the appellant's failure to testify or it was harmless. In his brief, the appellant argues that the trial court abused its discretion by denying his request for mistrial. During the punishment phase, the state remarked that in its closing argument that at no point during this trial has the appellant taken any responsibility. Appellant characterizes that statement as improper comment on his failure to testify and contends a mistrial was required. Appellant's claim fails for two reasons, which the state will discuss in turn. First reason, the challenge remark was a fair response to the intended or such character that the jury would necessarily or naturally take it to comment on appellant's decision not to testify. The state's argument addresses the appellant's failure to accept responsibility as reflected by the evidence presented at trial, matters improperly before the jury, and asserting a punishment. Because the record and the appellant's argument support the state's characterization, the comment was grounded in evidence and was not improper. Second, even if the remark was improper, any harm was cured by the trial court's instruction to the jury to disregard the statement. Jurors are presumed to follow the court's instructions, and such curative measures ordinarily solve any prejudicial circumstance. I'm going to say this: I believe that the biased juror I believe that there was no way to have. I believe that in Letitia Stouch's case, getting a new trial based on this biased juror is in extreme circumstances. This just very rarely happens, and it's a shame. But that would be an extreme circumstance. Nothing in his record suggests that the state engaged in a willful or calculated effort to deprive the appellant of a fair and impartial trial. Nor does this isolated remark rise to the level of an incurable harm. The jury charge further reinforced that the protection by expressly instructing jurors not to consider the appellant's failure to testify when determining a punishment. And I believe that's standard language in all of the charges given to the jury. So, finally, the state of the evidence confirms that the verdict would probably not have been different without the complaint or the complained of comment. Given the strength of the punishment evidence and the court's prompt curative instructions, error, if any, was harmless. Because the state's argument was proper or harmless, the trial court acted within its discretion in denying the motion for mistrial. Accordingly, appellant's fourth issue should be overruled. Now, in his fifth and sixth issues, because these defendants, these defendants always have multiple reasons why they think deserve a new trial. And they're always going to have statements of, oh gosh, their rights were violated. They always have their rights violated in these situations. We hear it every time we read a brief. That's one of the problems. Let's keep going here. So in his fifth and sixth issues, the appellant contends the trial court erred by denying his motion to suppress his custodial statement to law enforcement, arguing that the statement was obtained in violation of his Fifth and Sixth Amendments. The state of Texas respectfully disagrees because both issues arise from the same set of facts and raise overlapping constitutional claims that the state wishes to combine in its response. So, the issue presented. Does a trial court err by denying suppression of a custodial interrogation under the Fifth and Sixth Amendment when a criminal defendant reinitiates contact with law enforcement and waives his right to counsel. So all he had to do was say, no, I want a lawyer. I'm not going to talk to you guys. That's all he had to do. And this would not be an issue. So a summary of the argument. A trial court acts within its discretion by denying suppression of custodial interrogations under the 5th and 6th Amendments when a criminal defendant reinitiates contact with law enforcement and waives his right to counsel. Although the appellant contends that his right to counsel under the 5th and 6th Amendments were violated, the record shows that after invoking his right to counsel, the appellant himself reinitiated contact with law enforcement and requested to speak with the officers. So they had read him his rights. He wanted an attorney. He didn't want to talk to them. Then he decided he wants to talk to them. Before questioning resumed, he voluntarily, knowingly, and intelligently waived his rights. Under these circumstances, any prior invocation of the right to counsel did not bar further questioning, and the resulting statements were admissible. B. The standard of review. As the court has explained, a motion to suppress is reviewed under a bifurcated standard. So we know bifurcated means. We've talked about bifurcated before, which is when they're combining things. But we'll go ahead and give you the actual meaning of it. So I'll make sure I actually say it just right. Bifurcated. Okay. A bifurcated trial means the case is split into two separate phases instead of being decided all in one. In plain English, it means instead of deciding everything in one shot, the court breaks the trial into two parts, usually one phase for guilt and another phase for punishment. Okay, so that's what happened there. Now, first, the reviewing court affords almost total deference to a trial judge's determination of historical facts. The trial judge is solely the trier of the facts, and the judge is the credibility of the witnesses and the weight to be given to their testimony. He is entitled to believe or disbelieve all or part of the witness's testimony, even if the testimony is uncontroverted, because he has the opportunity to observe the witnesses in their demeanor and appearance. So the judge is just the trier of the facts. If the trial judge makes express findings of fact, the reviewing court reviews the evidence in light of the most favorable to his rulings and determines whether the evidence supports these factual findings. Second, the reviewing court reviews a trial court's application of the law. To the facts de novo, the reviewing court will sustain the trial court's rulings if the ruling is reasonably supported by the record and is correct on any theory of law applicable in the case. C. Relevant facts. After the appellant was apprehended in Gainesville, Texas, Ranger Stoner met with the appellant at the Cook County Jail. Ranger Stoner advised the appellant that because he was in custody, he would read the appellant its constitutional rights. Appellant interrupted Ranger Stoner, stating that he knew his rights and wanted an attorney. Ranger Stoner told appellant that he would read the rights anyway and did so. Ranger Stoner was then advised appellant of the charges against him, told him that an additional warrant would be forthcoming, and started arrangements for appellant's arraignment. After the appellant was arraigned, the magistrate, Judge Henry, for aggravated assault of a public servant, he asked for appointment of counsel. Appellant then further discussion with law enforcement about the individuals who had been arrested alongside him. When Judge Henry asked whether the appellant had any further, appellant asked about the possibility of waiving his rights to secure the release of the other individuals. An official advised the appellant that no questions could be asked unless the appellant chose to speak voluntarily, and told him that Ranger Stoner was the officer handling the investigation. The appellant repeatedly stated that he was waiving his rights to counsel. Ranger Stoner explained the appellant had asked for an attorney and clarified that any further discussion would require the appellant to assert that he wished to speak without counsel. In response, the appellant reaffirmed that he waived his rights. Ranger Stoner carefully repeated the appellant must express his desire to speak without counsel. Appellant then made an unsolicited admission, stating he was busted red-handed, that the other individuals were innocent, and that he was alone and was responsible for what occurred. He also acknowledged that he shouldn't have done it and characterized by his conduct as pretty stupid. Throughout this exchange, Ranger Stoner did not question the appellant about the offense, but ensured the appellant understood the consequences of the appellant's previous invocation of his right to counsel and the necessity of a clear waiver before any discussion moved forward. The appellant's statements were voluntarily and motivated by his desire to protect the other individuals rather than by any questioning, promises, or coercion by law enforcement. Before the trial, the appellant moved to suppress the statements made to Ranger Stoner, arguing that his rights were violated because he had invoked his right to counsel at the onset of the interview. Well, but you sat there and said, boy, does he not remember what he said? We just read what he said. During the hearing outside the jury's presence, the trial court reviewed the video recording of the interview. The trial court denied the motion to suppress, finding the appellant understood his rights, reinitiated contact with law enforcement, and knowingly, intelligently, and voluntarily waived his rights. Appellant also challenged the voluntariness of his confession, asserting that he did not validly waive his Miranda rights. The video recording, however, showed no sign the appellant was frightened, coerced, or otherwise compelled to provide his statement. D. Relevant law. His Fifth Amendment to the United States Constitution states, no person shall be compelled in any criminal case to witness against himself. To safeguard that privilege, law enforcement must meet the requirements established in the Miranda v. Arizona. Before custodial, well, let's talk about Miranda v. Arizona. Let's take a look. Hang on a second. We'll pull it up. Okay. Let's talk about that one. Okay. See. Ooh. In Miranda v. Arizona, this was in 1966. It's the case that created what we now know are called the Miranda rights. Before police can question someone in custody, they must inform them of their rights. The right to remain silent. Anything said can be used against them in court. The right to an attorney. If they can't afford one, one will be provided. If police don't give this warning statements made during custodial interrogations, they can be excluded from the evidence. So Ernest Miranda, this is in 1966, a guy named Ernesto Miranda was arrested and questioned. He was not informed of his rights. He confessed during police interrogations. That confession was used to convict him. The U.S. Supreme Court ruled that this violated the Fifth Amendment protection against self-incrimination. And voila, that's why you have Miranda rights from Ernest Miranda. Okay, now, before custodial interrogation begins, a suspect must be advised of their right to counsel. Statements obtained without this warning or without valid waiver of those rights are inadmissible. For a statement to be admitted, the state must show that the suspect knowingly, intelligently, and voluntarily waived those protections. When a suspect invokes their right to counsel during the custodial interrogation, officers may not continue questioning or reinitiate interrogation simply by re-advising the suspect of his rights. A valid waiver cannot be established by showing only if the suspect later responded to the police-initiated questioning. Instead, interrogations must stop unless the suspect himself initiates further communication with the authorities. A suspect's unwillingness to speak without counsel is presumed to continue unless he reopens the dialogue. So he has to come to them. Let me take a drink. Courts apply a two-step inquiry to determine whether a post-invocation statement is admissible. First, the state must prove that the suspect, not the law enforcement, initiated further discussions about the investigation. And second, the state must prove that after reinitiating the contact, the suspect executed a voluntarily, knowing, and intelligent waiver of the previous invoked right to counsel. Separate but related protections arise under the Sixth Amendment. Once the formal adversarial proceedings have begun, the Sixth Amendment right to counsel attaches and guarantees the accused the assistance of counsel at all critical stages of the prosecution. This right, like the protections recognized under the Miranda, may be voluntarily, knowingly, and intelligently waived. For either constitutional right, the state must prove an effective waiver. The admissibility of custodial statement depends on whether the state establishes by preponderance of the evidence that the accused validly waived his rights and that the statement was the product of free and deliberate choice rather than coercion. Reviewing courts use the totality of the circumstances approach. So let's look at this. We'll just talk about that for a minute. Totality of the circumstances. Okay. Here we go. Let's see what that approach is. The court looks at all the facts together, not just the one detail in isolation, to decide if something was lawful or fair. The court isn't going to focus on just one moment or one action. They step back and they look at the whole situation from start to finish. And depending on the issue, this can include what the defendant said or did, how police acted, the environment, pressure, timing, location, whether the rights were explained, and the overall context of the encounter. So how it applies in the Jerry Don Elder case is, the defense might argue this statement wasn't voluntary. The court's response is, we look at the totality of the circumstances, everything surrounding that statement. Okay, so where it gets important, this is where this gets important. The court doesn't just isolate, when they look at all of it, it's from start to finish, the full picture of the whole interrogation and everything that happened. Most of it's always taped, so they always have that to review. Anyway, so that's what that means. Okay. So they evaluate whether the defendant knowingly, intelligently, or voluntarily waived his Miranda rights. If the circumstances show an uncoerced choice and the requisite level of the comprehension, a court may conclude that an accused has effectively waived his rights. A statement is considered involuntarily when the official coercive conduct is so overbearing that the statement cannot be said to be result from free and voluntary act of free and voluntarily of the accused. Sorry about that. E. The appellant reinitiated contact with law enforcement and voluntarily, knowingly, and intelligently waived his right to counsel. Appellant contends the trial court was wrong to deny his motion to suppress his custodial interrogation, asserting that violations of his rights to counsel under the Fifth and Sixth Amendments. The record refutes that the claim. First, the evidence supports the trial court's finding that the appellant, not law enforcement, reinitiated contact. In its written findings of fact, the court found the appellant reinitiated the communication through both the magistrate and the law enforcement, and affirmatively stated that he wished to waive his rights. Remember, he's trying to take responsibility for all of it. He doesn't want his girlfriend and his friend to be charged. Appellant conveyed desire to speak with officers and asked whether other individuals connected to the offense could be released. The court further found that the appellant resumed contact after a long pause while waiting for the magistrate, showing the decision to speak originated with him rather than law enforcement prompting. Second, the record shows the appellant effectively waived his rights before questioning resumed. The evidence shows that the appellant seemed intelligent, articulate, and knowledgeable about both the offense and the investigation, and that he understood his rights explained to him, including his right to counsel. There is no credible evidence that he was frightened, coerced, or otherwise overborne at the time of the interview. The method of interrogation was not coercive, not improper, and he was not induced or promises were made. There was no promises made. And nothing suggests his statements were anything besides the product of free and deliberate choice. Given these facts and affording the almost total deference to the trial court's determinations of historical facts and credibility, the court acted within its discretion in denying his motion to suppress. Accordingly, appellant's sixth issue should be overruled. Oh my God, he just keeps going. Seventh issue. Okay. In his seventh issue, appellant contends the trial court erred by denying his motion to suppress the search warrant authorizing collections of his DNA, asserting a Fourth Amendment violation. Specifically, appellant argues that the affidavit supporting the warrant did not set forth sufficient facts, together with reasonable inference drawn from those facts to support probable cause. The state of Texas respectfully disagrees. Here is the issue represented with the DNA. Does the trial court abuse its discretion by denying motions to suppress a DNA search warrant when the supporting affidavit establishes probable cause and direct nexus between the defendant, the offense, and physical evidence likely to yield forensic results? Summary of the argument. A trial court acts within its discretion by denying motions to suppress DNA search warrants when the supporting affidavit establishes probable cause and a direct nexus between the defendant, the offense, and the physical evidence likely to yield relevant forensic results. Far from boilerplate, the affidavit in this case details specific facts tying the appellant to the victim, the vehicle, the offense, and including his confession, and it's recovered in the investigation. With all support, a reasonable inference that the appellant's DNA would yield relevant forensic evidence. These particularized facts gave the magistrate a substantial basis on which to issue the warrant, and the trial court properly denied the suppression. Standard of review. When reviewing a magistrate's decision to issue a search warrant, the appellate court uses a highly deferential standard of review, reflecting the Fourth Amendment's strong preference for searches conducted under a warrant. This deference encourages officers to use the warrant process and recognizes that the magistrate's role is of the neutral arbitrator of a probable cause. A reviewing court determines only whether the magistrate had substantial basis for concluding that the search warrant would probably uncover evidence of criminal activity. If the basis exists within the four corners of the affidavit, the probable cause determination must be upheld. Reviewing courts will not invalidate a warrant by interpreting an affidavit in a hyper-technical rather than a common sense manner. Okay, the relevant facts. On April 14, 2021, appellant was arrested for shooting Officer Lott. At the time of his apprehension in Gatesville, Texas, appellant had his truck belonging to Waddell. Investigators identified Waddell's truck as having involved in her murder and appellant's subsequent flight from Johnson County, Texas to Cook County, Texas. During a custodial interview, appellant admitted to investigators that he used a .38 caliber revolver to shoot both Officer Lott and Waddell. Appellant had also been linked to a burglary of a recreational vehicle that occurred after the murders in Johnson County. Law enforcement responded to the call and discovered the recreational vehicle had been rummaged through. Clothing with fluid had been left behind, and a wallet with a card belonging to the appellant was on the bed. A shotgun was stolen from the recreational vehicle and later located back in the back seat of Waddell's truck. April 16, 2021. Investigators executed a search warrant on Waddell's truck. During the search, investigators recovered the stolen shotgun. Investigators also recovered a silver Smith & Wesson .38 Special, a 5-shot revolver from the driver's side floorboard. Investigators swabbed the revolver for possible DNA, along with additional items from the vehicle, including the gear shifter, the steering wheel, and seatbelt buckle. On April 20, 2021, while the appellant remained in custody, he was arrested for the offense of capital murder in connection with Waddell's death. The search warrant authorizing the collection of appellant's DNA was signed on April 8, 2022. The supporting affidavit detailed items stolen from and left at the scene of the burglary, the possibility that DNA could be linked to the appellant. The shotgun stolen during the burglary was found inside Waddell's vehicle, where appellant had informed law enforcement it would be located. Waddell's truck was observed leaving the scene of her murder and was later tracked to Cook County. The affidavit further explained that the appellant's DNA was likely present on the murder weapon and within the victim's vehicle, and the DNA sample from the appellant would provide valuable evidence corroborating both the physical evidence and the appellant's own statements regarding Waddell's murder. On April 11, 2022, a Johnson County Sheriff's Office crime scene investigator collected a buccal swab from the appellant. Appellant's DNA was submitted to the Texas Department of Public Safety Crime Laboratory and compared to the swabs collected from the vehicle and the revolver. The resulting analysis showed a high probability that the DNA recovered from the gear shifter, steering wheel, and revolver originated from the appellant. Relevant Law D. Under Texas law, law enforcement officers may obtain and execute search warrants to collect an accused's DNA, but the warrant process is conditioned on a showing of probable cause supported by the affidavit. The Texas Code of Criminal Procedures requires that a sworn affidavit setting forth substantial facts establishing probable cause go along with every request for a warrant. Probable cause exists when considering the totality of the circumstances described in the affidavit. There is a fair probability or a substantial chance that evidence of a crime will be found in the place to be searched. To satisfy this standard, the affidavit must do more than just offer conclusory assertions. It must provide particularized facts and circumstances that allow the magistrate to independently evaluate whether probable cause exists. Thus, the reviewing court examines the four corners of the affidavit to determine whether it shows the specific offenses and that the items sought are evidence of the offenses or the suspect's involvement, and the evidence is probably in the place or on the person to be searched. Okay. E. The search warrant affidavit establishes probable cause and a direct nexus between the appellant's DNA and the murder investigation. Appellant contends the trial court erred in denying his motion to suppress the search warrant authorizing collection of his DNA, arguing that the affidavit included mere boilerplate and did not establish a nexus between the evidence sought and the offense. When read in common sense way, giving proper deference to the magistrate's determination, the affidavit provided a substantial basis for concluding that probable cause existed and the appellant's DNA would likely yield evidence relevant to the murder investigation. Here, the affidavit details specific facts directly tying appellant to the offense and physical evidence capable of forensic testing. The affidavit showed the appellant had an active arrest warrant for aggravated assault of a public servant when law enforcement received the information that a silver Toyota Tacoma drove through the back gate of the Joshua Police Department. The vehicle's registered owner, Waddell, was found nearby with 2 gunshot wounds and later died. Appellant was in Cook County possession at the same time and was observed fleeing from it. He confessed to murdering Waddell after forcing her to drive the vehicle, admitting using Waddell's phone, stated that he shot Waddell with a handgun and acknowledged leaving the handgun inside the vehicle. Officers also recovered appellant's wallet and boots associated with him at the burglary site. Based on these facts, the warrant sought a DNA sample to compare with the items listed in the affidavit. The facts established a straightforward evidentiary chain. The offense involved physical contact between the appellant, the victim, the vehicle, and the murder weapon. This contact reasonably supports the inference that DNA would be transferred. Collecting the appellant's DNA would allow investigators to confirm or exclude him as the contributor of any biological evidence recovered from the vehicle or the firearm. This is the direct nexus between the appellant and the physical evidence. Appellant incorrectly relies on State versus Baldwin. Well, let's look at State versus Baldwin and see what happened there. Okay. How it applies to this case. Let's see what they're trying to do. Okay, State versus Baldwin. Here's a simple breakdown of why they're trying to use it. Here's the core idea. State versus Baldwin is often cited for how appellate courts evaluate whether something that happened during trial actually rises to the level of reversible error. In cases like Baldwin, courts usually look at whether an error actually occurred, whether the error was preserved, properly objected to at trial, and most importantly, whether the error caused harm. Even if something went wrong during the trial, the conviction stands unless the error affected the defendant's substantial rights or the outcome of the case. This ties directly to harmless error doctrine and appellate's deference to the trial courts. Okay, so that is what they're talking about. They're talking about whenever, hang on just a second, guys, whether there was some kind of something that happened that was harmless, or whether it made a difference in the trial court's decision. And so this one case is used all the time in these briefs when somebody's trying to complain about this. Anyway, so State versus Baldwin. Baldwin involved a warrant to search a cell phone supported only by generic conclusions that the criminals commonly use phone, with no facts tying that phone to the crime. I can see why he's trying to use that, but that's not going to work in this case. This court rejected the warrant in Baldwin because it relied on a speculation rather than particularized facts. Here, however, the affidavit specifically connected appellant to the victims, the vehicle, and the firearm. Thus, unlike Baldwin's boilerplate only showing, the affidavit provided a direct and individualized nexus. Viewing the affidavit in a common sense way and affording proper deference to the magistrate's reasonable inferences, the magistrate had substantial basis to conclude that obtaining the appellant's DNA would probably produce evidence of the murder. Because the warrant was supported by probable cause and established required nexus, the trial court acted within its discretion in denying the appellant's motion to suppress. Accordingly, appellant's seventh issue is overruled. In his eighth issue, yes, he has a lot of issues here. In this case, the guy had a lot of issues. So we're on number 8 over here. Appellant argues that the trial court violated his rights under the Confrontation Clause by permitting Dr. Michael Chomp to testify regarding the cause and manner of Waddell's death, even though he did not conduct the autopsy or prepare the autopsy report. The state of Texas respectfully disagrees. Issues presented. Does a trial court abuse its discretion by admitting expert testimony from a witness who neither performed the autopsy nor prepared the autopsy report, but instead offered an independent opinion based on underlying data? Here we go. The summary of the argument. A trial court does not abuse its discretion by admitting independent expert testimony regarding manner or cause of death, even though the expert did not perform the autopsy or prepare autopsy reports. Dr. Chomp did not sponsor Dr. Rowe's autopsy report or act as a surrogate for Dr. Rowe, who conducted the autopsy and authored the report. Rather, Dr. Chomp offered his own independent opinion on the cause and manner of Waddell's death based on his review of the relevant materials. Therefore, the admission of Dr. Chomp's testimony did not violate Elder's Confrontational Clause rights. Standards of review. A reviewing court reviews a trial court's ruling on the admissibility of evidence under an abuse of discretion standard, and the reviewing court must uphold the trial court's ruling if it is within the zone of reasonable disagreement. We talked about that a while ago. Relevant facts. The state called Dr. Michael Chomp to testify. Dr. Chomp is employed by the Tarrant County Medical Examiner's Office, which is the TCME, and serves as a fellow in forensic pathology. Appellant objected to Dr. Chomp's testimony under the Confrontation Clause, arguing that Dr. Chomp neither conducted Waddell's autopsy nor prepared the report. The trial court overruled the objection and ruled that Dr. Chomp could testify regarding his independent conclusions about the cause and manner of the death, explaining how independently reached those conclusions. During the trial, Dr. Chomp testified that another doctor, Dr. Rowe, performed the Waddell's autopsy and authored the autopsy report, but that Dr. Rowe was no longer employed by the TCME. Dr. Chomp explained that, in forming his opinions, he reviewed the autopsy report, the anatomical diagrams, the toxicology results, and the chain of custody documents, the report of identification, the investigator's report, the photographs, and x-rays. Based on his independent review of these materials, Dr. Chomp reached his own conclusion regarding the cause and manner of Waddell's death. Appellants renewed his objections under the Confrontational Clause and the rule against hearsay during Chomp's testimony. The trial court overruled those objections. Dr. Chomp testified that Waddell's cause of death was multiple gunshot wounds and the manner of the death was a homicide. He further detailed that Waddell sustained 4 gunshot wounds, one to the back of the arm, one to the front of the arm, one to the right side of the breast, and the upper right part of the back. Relevant in law. The Sixth Amendment guarantees a criminal defendant the right to be confronted with the witnesses against him. The Supreme Court has limited this protection to testimonial statements, holding that such statements are inadmissible unless the declarant appears for cross-examination or is unavailable and the defendant previously had an opportunity to cross-examine the witness. At the same time, the Confrontation Clause does not require the state to call every person involved in the chain of custody, authentication of evidence, or operation testing procedures. Rather, the constitutional concern arises when a testifying witness merely serves as a conduit for the truthfulness of an absent analyst's assertions. Because the other ME was not employed there anymore, then Dr. Chomp became the person that gave the statement. So, when a witness offers an independent opinion rather than repeating another's testimonial statements, the Confrontation Clause is not implicated. Dr. Chomp's independent expert testimony did not violate the Confrontation Clause. Appellant contends the trial court abused its discretion by admitting the testimony of Dr. Chomp, arguing that his testimony violated the Confrontation Clause because Dr. Chomp did not perform the autopsy. Appellant's implicit argument is that only the medical examiner who conducted the autopsy could testify regarding the number of gunshot wounds. The argument misstates both the record and the governing law. The Confrontational Clause prohibits the state from introducing an absent analyst's testimony statements through a surrogate witness who merely parrots another expert's conclusions. But this is not what occurred here. Dr. Chomp did not rely or recite Dr. Rowe's findings. Instead, he reviewed the underlying materials, including previously admitted autopsy photographs, and testified to his own independent medical opinions on the manner and the cause of death. His testimony reflected his personal analysis and conclusions, not the assertions of another examiner. An appellant attempts to rely on Smith v. Arizona to support his assertions. Well, let's look up Smith v. Arizona. Hang on a second. Let's see what's going on there. Why did he want to use that? Okay. So, in the Confrontation Clause case, meaning it deals with the defendant's right under the Sixth Amendment to confront or cross-examine the witness against them. Can the prosecution use statements or conclusions from someone who does not testify in court, especially through another witness like an expert? And here's what that case was about in Smith versus Arizona. An expert witness relies on work done by someone else, which we know that's not what happened. He formed his own opinion. The original person does not testify. She was no longer employed. And the defense cannot cross-examine them. But he could cross-examine this person. So, in short, this kind of issue can be huge on appeal, because if the key evidence came in without proper confrontation, that's not just a mistake, that's a violation. But that's not what happened here. So here we go. So appellant attempts just okay. In Smith, the Supreme Court disapproved the admission of testimonial statements from a non-testifying analyst through a substitute witness. Here, Dr. Chomp was not acting as a surrogate for Dr. Rowe's opinion. He independently evaluated the evidence and identified and counted the visible gunshot wounds depicted in the photographs. Because those photographs were admitted exhibits and are not themselves testimonial, his testimony was based on those materials and did not implicate the confrontational clause. Dr. Chomp testified as an independent expert, not a surrogate. The trial court acted within its discretion in admitting the testimony. Accordingly, the appellant's eighth issue should be overruled. And that is the conclusion prayer. So that is the brief that goes along with this case, and that is what he's complaining about with his trial. Now, what we're going to do next is we're going to actually watch the oral arguments. These oral arguments were done on, I think, April the 15th. Hang on a second. Make sure I've got the date correct. This is new. The opinion has not been brought down yet. This is all brand new. So, let's see. Okay, so let me share my screen. Let's get rid of this one. Okay, unshare the screen, and let's share the screen so we can watch the oral arguments. Okay, here we go. Now, let me get this set up for you. And this is going to be the Texas Court of Criminal Appeals. Let me give them full credit. Okay, get over there. All right, now go back over here. So let's give full credit to the Texas Court of Criminal Appeals. Okay. Okay. Now, put this over here. Right there. Hey, girl. Hey, Sprinkle. I was just reading along. Didn't know you were sitting there. Thank you so much. I just wanted to do this today and get, because I wanted to read this because it's a new one and the actual opinion has not come out yet. This just happened on April the 15th. So we're going to go ahead and show the oral arguments, because, you know, I love watching the oral arguments and I love watching the trials. Here we go. Here we go, guys. Hang on. Oh, I need to back over here. Oh, did I share my screen? Hello, silly. Let's share our screen here. All right. Share. All right. So let's get going on this. Let me make the screen bigger. And we're going to go with the Supreme Court of Texas. Here we go, guys. All right. Let me see if I can get it to go. Is it loud enough? Okay, there we go. All right. We'll wait for the judges to come in. We can just talk amongst ourselves, but we'll wait for the judges to come in. I thought it was pretty interesting that some of these same objections end up in all of these. We've seen them in all of these appeals that we read. You know, they use the same old, you know, violation of their rights in all these appeals. It's kind of interesting. I know the guy mentioned something about boilerplates. Yeah, because all these legal documents come from kind of a boilerplate, and then they do just put their own language into it about what happened. But they all start out, you know, from the same platform, the same document. They just make the right changes. I understand that, but hang on. Mouth is kind of dry. It's been raining all day here. It's cool. It's cold. Jack does not feel good. Kind of bothering me, you know. Let's see. Let me see what the temperature is outside. I mean, it was cold. It's not supposed to be cold now. Let me pull this back up. Okay. Now. Yes, in Leander, Texas, it's currently 64 degrees and raining. Oh, here they come. And it's supposed to rain all night. Okay, here we go. Let's get ready to go.
Oh yay. The Honorable Court of Criminal Appeals is now in session. All persons having business before the court are admonished to draw near and give their attention, for the court is now sitting. God save Texas and its honorable.
Please be seated.
Okay.
Is Mr. Bratt here with us today? Mr. Bratt? Butch Bratt? All right. Apparently not. I'm going to move on then to AP 77123, Jerry Don Elders versus the state of Texas. I'll ask counsel to approach if they would. I understand we will be hearing first from, is it Mr. Gill?
Yes, sir.
15 minutes for the appellant. You are reserving 5 for rebuttal.
Yes, sir.
Okay, and then we'll hear from Mr. Judd
Yes, sir.
for the state. Thank you so much. Mr. Gill, whenever you're ready, please feel free to get started.
Morning.
Good morning.
My name is Bob Gill. I'm with the Fort Worth law firm of Gill and Brissett. I'm here on behalf of Mr. Jerry Don Elders, appellant, a case out of Johnson County, Texas. 2 years ago, in May of 2024, Mr. Elders was convicted of the offense of capital murder by a Johnson County jury, and he was given the death penalty. Some of the facts of the case briefly are important to the decision on my grounds 1 through 3, dealing with the fact that I was not allowed to ask certain questions during the voir dire of a particular environment. The series of offenses for which Mr. Elders was convicted and given the death penalty began with the shooting of a Burleson, Texas police officer. His name was Officer Joshua Lott. Officer Lott pulled Mr. Elders and 2 other occupants of the vehicle over on a traffic stop late at night. As Lott approached the passenger side of the vehicle, Elders reached across the front passenger and fired 3 shots, striking Lott in the neck and upper chest area. Fortunately, Officer Lott was able to survive. The crime scene, then Mr. Elders headed west. What he was actually tried for was the shooting of a woman whose vehicle he stole and used that vehicle and flee north up towards the Oklahoma border.
Okay, you know, we have to stop every once in a while for fair use. And so I thought that the officer had passed away, but that's not true. So he survived. But it's capital punishment because he killed this lady while he was also robbing. You know, he was stealing. So that causes capital punishment in the state of Texas. If you are with a weapon and you take somebody's life in the act of a robbery. Okay, here we go. Sorry. Come on.
The importance of the beginning of the chain of events to these grounds of errors is that we had a fireman named McGee who was very closely associated with members of the Burleson Police Department. McGee was a member of a church in Burleson, a large church, and the security detail was sponsored by a Burleson police lieutenant who ran their security detail and sponsored their private investigator security cards. McGee, the fireman, very closely worked with several members of the Burleson Police Department.
Just quickly, the fireman means the person that they were in voir dire, and this is the person they were questioning in voir dire. So that's what the fireman is. Here we go.
He knew of Officer Lott. On the day of the shooting, he was in contact with several members of the Burleson Police Department, keeping track of the events regarding the shooting, keeping track of Officer Lott's condition. He was concerned for the safety of his wife, who taught school at a location in Burleson because Elders was on the run for most of the day. So when we got around to the voir dire of Van Arm and McGee, it became very apparent that we needed to learn about the extent of his views based upon what he'd heard and what he had read. He'd also read some online articles about the case, and had followed it in various degrees while it was progressing through the courts. So it was very important to know from him what his attitudes were about those things, and whether or not, knowing everything he knew, he would be able to be a fair and impartial juror.
Counsel, let me just distract you for a moment. Vanierman McGee was not impaneled, correct?
Correct.
He was struck for cause.
No, sir, we actually.
Or, excuse me, I apologize. He was struck with a peremptory.
Yes, sir.
And then your client was given 4 additional peremptories over the peremptories he had originally.
That is correct.
So I understand that there were 7 ultimately struck. Is that correct?
Judge,
Peremptories plus 4 additional peremptories?
Yes, sir.
And this particular Vanierman, or they were not impaneled.
Correct.
These were done individually, so no other impaneled juror heard any of these questions or this line of questions.
Yes, sir. That is correct.
So I understand where you're going, but I need you to help me get past that.
Okay.
This veneer person was not impaneled, and your client was given additional peremptory challenge.
And we ended up with persons on the jurors that we,
I think the reason why he's asking that because it's no harm. There was no harm done here. So why is this even an issue? I mean, he wasn't on the jury. There's no harm done. This is a ridiculous and it's a waste of the court's time. But here we go.
felt were objectionable jurors. But we felt like this Vanierman should have been challenged for cause. If we'd have been able to ask these questions, we would have been able to develop a valid challenge for cause. And that's what all this goes to.
I believe that what Judge Finley is pushing on is the question of how are you harmed by this? If you got additional peremptory challenges after you had to use a peremptory on this prospective juror, how were you harmed?
Because we had to use that additional peremptory challenge on another juror we felt was objectionable, and then had to ultimately seat persons we felt were objectionable on the jury that we could have used.
At the end of the selection process, did you identify an additional juror as to whom you would have exercised a
I
peremptory?
do not recall if we did that or not, Judge. But as far as the question goes, the underpinning of that question, of the questions we sought to ask, and I'm going to concentrate mostly on my third question, which was basically tailored out of Code of Criminal Procedure Article 3516A10, which deals with publicity. And it deals with after a juror or potential juror has heard an amount of publicity, based upon that, have they formed any type of opinion or conclusion? So that takes the question out of being a stand for improper commitment question, because 3516A10 is one of the few voir dire questions, one of the few areas of voir dire where facts are actually important to the analysis and actually important to the question being asked. So when we talk about a standard for analysis, are there facts in the question that go to a challenge for cause, or is it just strictly a legal issue? This is the type of question that requires facts to be in the question. So it can't be an invalid and proper commitment question under Standifer. It's not a vague or overly broad question because it goes directly to a challenge for cause. We were seeking to find out from this Vanierman, based upon what he had heard, did he already form an opinion as to the punishment in this case? Did he already have his mind made up as to whether or not he was going to automatically give Mr. Elders the death penalty because he had already formed an opinion or conclusion based upon what he had heard and based upon his associations with other members of the Burleson Police Department? So that takes it out of the area of being an objectionable question, because it's not a Standifer question. It's not overly broad. It's not vague.
But did you ask that question as it's laid out in the statute?
We asked it very closely the way it was laid out in the statute. The statute is, have you formed an opinion as to guilt or innocence of the client?
In this case?
In this case.
Right.
Yes. In this case, we asked it being a death penalty case, we asked the question in terms of punishment. So we turned the 3516A10 a little bit differently and asked it, would you be able to, what have you heard? And how does it affect you on your ability to set punishment in the case?
But did you limit it to this case, or did you make it more generic than that?
No, it was limited to this case. It was based upon what you've heard about the shooting of the Burleson police officer.
And would you be able to fairly assess punishment in this case?
Yes.
The counsel, 2 questions. First, he wasn't tried for shooting the Burleson police officer, correct?
That's correct.
And then you also came back in your voir dire of Vanierman McGee, and you said, So you have absolutely no opinion about what went on with Officer Lott back in April of 2021. That question was permitted, correct?
It was.
And Veneerman said, I don't recall an opinion.
Right.
And you went again through, I've got the transcript here, you went it through and you were allowed to effectively address this issue with the veneer person. You just had that one specific phraseology of the issue. That objection was sustained by the state, or by the judge. The state's objection on that phraseology was sustained, but you got to get into it later.
We were allowed to ask what I would refer.
Sorry. I'll talk about this for just a second. The panel of judges, the reason why the questions is that he was not even tried for shooting the police officer. He was tried for shooting this Waddell person in the act of a robbery, and this person died. Okay? So this questioning about this juror is ridiculous, and I can see where it is a waste of the court's time, because this is that shooting, the police officer question has nothing to do with it. He was not on trial for the police officer. So here we go.
Which was the content questions. The questions about what he heard, how he heard it, what he knew about the facts of the case. But
Then distinguish for me. Distinguish the significant difference between how you phrased the issue originally, where the state's objection was sustained, and how you phrased it subsequently, where the state did not object.
Wow.
it's Moo Min versus Virginia.
All right, parse that out.
Okay? Moo Min, Supreme Court of the United States case, said that it's essential that in a case involving punishment, that the defendant be allowed to ask questions that go to a valid challenge for cause on the ultimate issue of the fireman's ability to be fair and impartial. In this case, on punishment. In that case, it was a punishment issue also. The court said that the content questions, the questions about what he heard, how he heard it, etc., are not constitutionally required.
What he heard about offense he was not being tried for.
Correct.
Okay.
Correct. So in this case, it's kind of the opposite of Moo Min. We were allowed to ask the content questions, which were basically prohibited by Moo Min, or found to not be constitutionally relevant, but we were not allowed to ask what Moo Min said were the constitutionally relevant questions of, can you be fair and impartial based upon what you've heard?
But
So
you
that-
were permitted to ask him if he had formed an opinion, and he assured you he had not.
Yes, but we weren't allowed to ask the question about, would your opinion affect you as to the punishment in the case, which is what goes to the challenge for cause and what goes to his ability to be fair and impartial in the case. So this is the reverse situation of what the court ruled on in Moo Min, that the content questions were not constitutionally mandated, but the partiality question that goes to the challenge for cause was
I
constitutionally mandated.
understand the nuance you're trying to make. I'm not sure I agree with you, but I understand it. But again, how is there harm, even assuming I adopt the nuance you're trying to make, how is there harm when this Veneerman was not impaneled and your client was given additional peremptory strikes?
Because we would have used those peremptory challenges on someone else.
Who?
Well, at the end of the voir dire, at the end of the jury selection, there was I don't remember the woman's name, but had been a colonel in the U.S. military. And she was not a good defense juror. And
But you might have used it there.
we would have used a peremptory challenge.
I asked you that question a little while ago. Did you ask the trial court to give you that extra peremptory challenge so you could exercise?
I'm sure we did.
As I recall, you asked for 7, you got 4, but you didn't identify any additional specific juror you would use an additional peremptory on. I could be wrong, though.
I do not recall whether we did or not. I did not go back and look at that part of the record. But I do remember that particular juror and would have liked to have used it.
He did not go back and look at that part of the record before he comes in front of the panel of judges to make his argument. Well, he should have looked at that. He should have known they're going to ask these questions, and they're going to know what juror did you want to use this on that now you couldn't, and how did that harm you, right? But the question to myself, the question I have about all of it is, if you were not even he's not even on trial for shooting the police officer, he's on trial for this other act, then what has this got to do with it? It doesn't matter what this person thinks about. It's a ridiculous argument. Here we go.
peremptory challenge on her.
I mean, I'm telling you, I'm projecting to you.
Yes, sir.
The harm issue is a problem for me, so I'm going to have to solve it.
Yes, sir.
That timing is from the
So
court.
this area has been a confusing area for practitioners. It's been a confusing area for courts. Despite its importance, the adequacy of voir dire is not something that's easily ruled on by the appellate courts. There's a lot of back and forth about what questions should be permitted. There's a lot of back and forth in the courts about what harm standard should be employed. Cases like Jones, decided in 2007, 5-4 decision, recently overruled by Jacobs. Jacobs was a divided case also with a strong dissent. Standifer was a 5-4 case. Barajas, a 6-1-2. Even Moomin, we talked about a minute ago, was a 5-3 case.
Are your challenges on the questions limited to just McGee or across the board to all those members of the Venire?
This particular issue is limited to McGee because McGee was the one individual on this Venire that had these close connections to the Burleson Police Department and had the close connections to law enforcement and really had the closest connection of any Venireman to the most knowledge of any Venireman about the facts of the case.
Okay, just to reiterate, you had to burn a peremptory to get rid of him, but you were given additional challenges after that, correct?
Yes.
Okay.
Yes.
More challenges than that one.
4.
Right.
Yes, sir. Yes, sir.
You know, from those of us that are just looking in, watching this, you can see why the judges are frustrated because he's arguing a point where he was awarded he got extra strikes, which, okay, that was nice, right? But this juror and his thoughts on the police department have nothing to do with it because this person was not tried for the shooting of the police officer. And they are so frustrated, I can tell by the looks in their faces. Let's keep going.
So, goes without saying that the trial court has broad discretion to control the questioning of Venireman, and that's where the Barajas case comes in. The questions can't be overly broad. They can't be vague. They have to go to something. And when they go to a valid challenge for cause, that's when the U.S. Constitution steps in. In
How
capital
many
cases,
challenges? Can I just interrupt just for a second?
Sure.
How many challenges for cause were you entitled to as a matter of law?
we're entitled to an unlimited number of challenges for cause.
Oh, I'm sorry. I mistake. I said it wrong. Peremptory challenges. How many peremptory challenges were you entitled to as a matter of law?
Peremptory, we start with 15.
So you got 4 extra,
Yes, sir.
but you're only complaining about being denied the opportunity to ask this question of one of the veneer panel.
Yes.
So you got an extra strike, at least the first one out of the 4 that were new, that were given to you, and you exercised a peremptory challenge against this veneer member. And so you still got 3 more peremptory challenges. So how did you use those? And why didn't your ability to have those 3 extra challenges cure any problem here?
Well, with all due respect to Mr. Judge, who represents Johnson County, this was a Johnson County jury. There were a lot of objectionable jurors on this jury.
With respect, that
Are there
happens.
ever not
Police
objectionable jurors in
officers.
investigation?
Yeah.
I see your light is red. I'm going to give you a couple more minutes. You have also designated, I think it's issue number 5.
Yes, sir. Yes, sir. And that is a strongly fact-based issue that I wanted to stress some of the facts on that issue because our underlying contention in 5 and 6 is that the Texas Rangers did not scrupulously honor Mr. Elder's unequivocal invocation of his Fifth Amendment right to counsel.
Is it really their fault, though? I mean, your client was being magistrated at the time this pivot came back to to the Rangers, and I think a sheriff's deputy was there too. I mean, isn't that really the problem? I mean, there was not a sterile room to conduct this magistration in.
That was part of the problem, but overall, what happened was, once Elders received his Miranda warnings from the Texas Ranger, and before the Ranger got through reading him the warnings, he said, "I know my rights, I want a lawyer." They stayed with him, and they kept talking to him, and they kept contacting him, and they kept badgering him about the facts of the
Counsel, are
case.
you complaining about Fifth Amendment right or Sixth Amendment right?
I'm complaining about both.
Okay, well then let me ask you this. As to the Sixth Amendment right, you would agree that that right attaches during the initiation of the judicial proceeding, correct?
Yes,
Okay, and the magistration, from your point, is what initiates that judicial proceeding.
yes,
But your client was not magistrated on this charge. Your client was magistrated on the ag assault public servant, the drug possession, and the theft. He was not magistrated as it relates to the charge he was convicted of, which is the killing of the woman in the truck. So why is it you contend that the Sixth Amendment right attached, because Sixth Amendment rights are offense specific, he was not magistrated on that offense?
because it's all part of one scheme.
Amendment right, then the officers would have to stop intervening as to these offenses. But as it applies to your claim that you're asserting a Sixth Amendment violation, the Sixth Amendment right attaches when he's magistrated. And it is indisputed, he was not magistrated for this offense. So how then does this Sixth Amendment right attach such that it could have been violated?
Well, our contention is that it attached to the ag assault on police officer charge,
For which he was not tried.
for which he was not tried, but that was part and parcel. And he ended up confessing to the whole set of facts, which ended up being used against him in his trial.
So then are you asserting that the confession to an offense in and of itself triggers the Sixth Amendment right to counsel?
No, sir, I'm not. I'm just saying.
And if he wasn't magistrated for the offense he was tried for, how is your argument that his Sixth Amendment right was violated from that point, at that point? How does that hold?
Because it was all one set of facts.
Again, Fifth Amendment, sure,
Yes, sir.
but Sixth Amendment is offense specific. Are you asking this?
Okay. Well, this judge is clearly getting irritated because, again, he's bringing all these issues, and this is not even what the person was tried for. Mr. Elders was not tried for this. So I don't understand why he keeps going on about this. And I can tell you, this set of judges right here, I don't think he's going to win. I think this appeal is going to be denied because he's griping about the wrong case. Here we go.
Court to hold that the Sixth Amendment right to counsel is not offense specific?
Well, I wrote it under both constitutional provisions so that the court could give a full review to the entire set of facts. And I agree with you that the Fifth Amendment claim is a stronger claim.
Yes.
But I wanted to include the Sixth Amendment because the Sixth Amendment is also
In for one, in for two?
in for one, in for two. Okay,
I just want to make the distinction.
fair enough. But the Texas Ranger, the crux of the matter is that the Ranger did not leave him alone. I've gone
Sir,
over my whatever you gave me. I've
May I
gone
ask
over it.
a question? I don't see that in the record, that the Ranger did not leave him alone. It seems to be an overstatement on your part because repeatedly the appellant, well, several times the appellant is saying, I want to help my friends. I want to get them out. I don't want them to be responsible, basically, is what he's saying. To which the Ranger, at least here I have, says, we have to wait for your representation at that point. And the Ranger seemed to tell him that a couple of times. Maybe you could point to me in the record where this badgering is taking place. I don't see it.
Let me get you a page number. Okay, actually, I'm citing out of State's Exhibit number 5, which is the video recording of the statement. And right after Elders invokes his right and tells him he does not want to talk to them without a lawyer being present, they continue talking to him about what they're going to do, how the process is going to work, and where he's going to go.
That's the magistrate.
That's Ranger Stoner right after Elders first invokes his right. he starts telling Elders about, we're gonna take you back to Johnson County, or we're gonna get you magistrated, and we're gonna take you back to Johnson County, and we're gonna do this, and we're gonna do that. And they just kept talking to him about the situation involved, about the facts of the case.
Are we talking about the video of him in the room just before, during, and after he's magistrated?
Yes, Judge.
Okay, I just want to make sure we're talking about the same thing.
Yes, Judge.
So
We are.
please answer Judge Parker's question then.
Yeah, I'm looking at some of what you're talking about. I don't see how that's badgering him, telling him this is the next step in the process. We're going to have you magistrated, et cetera, et cetera. I don't see that they're pushing on him to make a confession or badgering him in any way at this point when he's actually questioning them about how to help his friends.
The badgering doesn't start until after he's magistrated, but they keep talking to him and keep talking to him about the case between the time he invokes his rights and the time the magistrate comes in. Then when the magistrate comes in, Elder starts talking about what he can do he starts talking to the magistrate about what he can do for his friends. And then that's when law enforcement officers begin again talking to him about the fact situation and what he can do with his friend for his friends.
That's where you'll have to clarify, because as I read the transcript, and I've got it here, he is the one who initiates the conversation about how to help his friend.
He initiates that with the magistrate.
And the magistrate tells them you'll have to go talk to those police officers.
Yes.
That's my
Yes.
point about sort of a non-sterile environment. We're doing
Yes.
part magistration, part people walking in and out of the door.
Yes.
Right. Okay, well, I think we've had a few extra minutes. I wanted to make sure we got that out before the state had a
Thank
chance to talk.
thank
We'll
you,
have
Judge.
5 minutes for rebuttal. Thank
I
you, Mr.
appreciate
Hill. We'll now hear from counsel for the state. Mr. Judd.
Yes, sir. May it please the court. My name is Jason Judd, and I am proud to represent Johnson County on behalf of the state of Texas in this case. This case involves straightforward presentation of settled law. Issues 1 through 3 involve improper commitment questions, not bias inquiries. Issues 5 and 6 show that appellant reinitiated contact, waived his rights, and chose to speak. Each ruling falls squarely within the trial court's discretion. I welcome the court's questions. Focusing on the third question in issue 3 of appellant's brief, Judge Keel, I believe you asked what specifically was asked of Venire member McGee during his individualized voir dire. In page 69 and 70 on volume 16 of the reporter's record, appellant's trial counsel had asked, quote, based upon what you have heard in Burleson to a certain unnamed police officer in April of 2021, have you formed an opinion or any conclusions about what ought to happen to the person, anybody found guilty or to have found to have perpetuated the shooting? Understand, this is an impermissible try to set the hypothetical parameters of the Venire member's decision-making. They are not asking about bias. They are asking what should happen, not even to a hypothetical, but the actual facts in this case. But appellant's argument is unpersuasive under Article 3516A10 because that is focused on guilt or innocence. And in this case, he was not charged or tried for the aggravated assault of a public servant. He was charged for capital murder during the course of his murder of Patricia Waddell. Fundamentally, we are looking at an abuse of discretion under Hernandez versus State, which this court decided in 2012, because the trial court does have a broad control over voir dire to prevent global fishing expeditions. Counsel, let me interrupt you for a second. So isn't there a difference between the prosecutor or the defense sort of feeding facts to a panel member and then asking them, okay, I fed you these facts, what do you think? Versus asking them, versus the Venire member having facts, you can use those in quotes or not, and then being asked, what do you want to do with what would you do with these facts that you have? Isn't there a difference between those two situations?
Judge McClure, I do believe that there is a difference in that essentially what appellant's trial counsel was asking was not whether they could follow the law, but they were asking what should happen in terms of a hypothetical set of facts that were present during voir dire.
But I mean, obviously nothing's going to happen that's not
within the law, right? I mean, you'd agree. I mean, the death penalty is going to be in the jury charge. So, I mean, isn't that basically the same thing?
Not necessarily, and I think that what hinges on this is appellant's oral argument. He seems to be trying to misconstrue Article 35A10 because it clearly does go to guilt or innocence. And because we do have a bifurcated trial system, if the legislature wanted to enact a statute in the Code of Criminal Procedure that would allow them to address special issues 1 or 2 to where trial counsel could elicit those types of questions, that could be appropriate, but appellant cannot rely on that statute.
I know, but isn't that why he's relying on sort of a constitutional theory that a defendant's entitled to ask these questions when death's on the table?
Your Honor, the defense is entitled to voir dire, but that is subject to the discretion of the judge. And because they do have this wide zone of reasonable disagreement, the judge can make these decision calls to say you are not allowed to ask these types of improper questions. This is not a case in which the trial court had prevented appellant's trial counsel from eliciting questions regarding bias. They are merely preventing global fishing expeditions and asking jurors to set hypothetical parameters for future decision-making, especially considering that these are the exact facts. And under Standiford, those would be too many facts in order to ask a hypothetically correct question under Standiford.
If we're going to allow, as we do, lawyers in cases to exercise peremptory challenges, I mean, peremptory means for whatever reason, I just don't like this person, I want him off. Shouldn't the default be pretty liberal towards allowing the lawyer to identify the jurors that he's comfortable with?
Your Honor, that would go to the abuse of discretion standard of review.
I'm just trying to get to how high that trigger is for abuse of discretion when it's the lawyers trying the case. It's their case and it's their client's life that's on the line, right?
Yes, Your Honor. Mr. Presiding Judge, the question here is the trial court on the ground is in the best position to be able to determine.
That's always going to be true. Right?
Yes,
By
Your
the time we get here, it's always true. So you've got to give some guidance to these trial judges about when they ought to be injecting themselves to influence the way that lawyers are trying to get information about bias. I mean, lawyers can ask questions about what cable news network they prefer to watch, right?
Yes, Your Honor.
I mean, they need to know who these people are, right?
That's correct, Your Honor. But I think the state would argue that in this case, these questions are not only overbroad, but because they are trying to focus not on any kind of bias that would allow them to exercise a strike for cause. Using that thinking, this court has struggled with how much discretion a trial court does have. But my understanding of Hernandez versus State is if things are overly broad, voir dire could be limitless. And because we already allow individual voir dire in a capital case, and because in this case, the trial court had subsequently allowed appellant's trial counsel to ask other types of questions that might elicit bias, in this case, the facts of this case would not allow a trial court to go outside of the zone of reasonable disagreement and deprive them of their lawful discretion to keep the trial moving.
Apart from these questions, what did he already know about the Venarman that would have allowed him to know, I got to exercise a peremptory on this guy?
Your Honor, my understanding of volume 16 of the reporter's record is this was a very lengthy voir dire, and in appellant's oral argument, he was able to elicit to this court even today all that he had known about Venire member Jeffrey McGee and his relationship with the Burleson Police Department and his prior knowledge of Officer Lott's shooting that occurred in April of 2021. This is not a case in which the judge is not allowing them to elicit any information that might allow them to exercise their peremptory strikes or their strikes for cause. The judge is just preventing appellant's trial counsel from saying, what do you want to see happen with this case? Because at the end of the day, this would be some of the evidence that might be elicited in the state's case in the punishment charge during the punishment trial as to issues special issues 1 and 2.
Counsel, let me ask you something. There's a certain finite amount of time to do this voir dire, practically speaking, correct?
Yes, Your Honor.
Okay. Then the more peremptory strikes the court affords the defendant, shouldn't that then argue to us that the trial court's discretion should be broader in narrowing the question? In other words, if the amount of harm that's likely to occur by preventing a question of a veneer person is reduced by increasing the number of peremptory charges the defendant has, then doesn't the greater number of peremptory charges argue for allowing the trial court greater latitude to limit the questions?
Judge Finley, I do believe that that could go into harm analysis under the Texas Rule of Appellate Procedure 44.2b, especially because he was not seated on the jury. And this court has previously stated in Jacobs versus State in 2018, one of the focuses of this is about the fundamental unfairness of preventing.
I understand the harm analysis, and obviously that's something I'm concerned with. I'm talking here about the latitude we should afford the trial court in its discretion to narrow the question of a potential veneer person.
Your Honor, the state would be willing to at least entertain the argument that by broadening the discretion by allowing for extra peremptory strikes, that would expand the zone of reasonable disagreement that the trial court is allowed to use in preventing appellant's trial court's counsel during voir dire. That's not something that the state had briefed for this case. However, I do think that that could be a helpful factor in determining whether or not the judge was acting reasonably or with any kind of operating guiding principles when they were deciding to limit appellant's voir dire during this trial.
Focus clearly for me briefly, please, on the issue of harm here, given that this veneer person was not seated and additional peremptories were given.
In appellant's brief, Your Honor, appellant states that harm is presumed, and he had cited in support of his position Aldridge versus State, which was decided by this court in 1991.
I'm not seeing that connection.
Well, that's entirely correct, Your Honor, because that case had been subsequently overturned, at least as to that, by Easley versus State, which was decided by this court in 2014. This court would just use regular non-constitutional harm factors to determine that if there was any error, it was not harmful to the defendant.
So what's the state's strongest argument that there wasn't harm here with respect to Veneerman McGee?
In this case, if you look at how other voir dire is limited, he did not ask for extra peremptory strikes, and I think that that kind of belies the idea that it didn't really harm him. But
he didn't ask for specific additional peremptories based on this veneer.
That's
he
correct.
Asked for 7 additional, he was given 4.
That's correct, Your Honor. And under my understanding of how peremptory challenges work, and if you are being deprived of a fair and impartial juror in that way, you need to ask for additional ones, and you need to say, this person was seated, otherwise because you would not allow me that type of peremptory strike. But because in this case, the trial court did properly exercise its discretion, and because that specific question, along with the previous 2 that were briefed in appellant's opening brief, they were improper and they were properly excluded, which brings me to my second issue, which is issues 4, 5, and 6, which is whether the trial court was wrong to deny suppression where the appellant had reinitiated contact and he had waived his counsel.
But let me focus on that then. It's pretty clear that would the state agree that the defendant here did invoke his 5th Amendment right prior to these confessions?
Yes, Your Honor, he did.
So leaving aside the 6th Amendment, go to the 5th Amendment. What's the strongest argument that he subsequently waived that?
So first, he reinitiated, and if we look to the trial court's findings of fact and conclusions of law, which were a supplemental court's record, they lay out the entire part where the appellant was taken to the Cook County Jail up in Gainesville, and after he was magistrated by Judge Henry, he specifically asked to speak with officers.
Well, wait, it's after he was, I mean, wasn't the magistrate still in the room when the officers came back in?
Yes, Your Honor, and I don't mean to suggest that he was transported somewhere else. If we look at State's Exhibit 5 at approximately 4:25:54 p.m., Judge Henry asked the appellant if he has any questions, and at that point he says, "Yes, I do. I want to talk," and then he is immediately directed to Ranger Stone.
That's sort of my concern here. I'll put some cards on the table. We're doing a magistration. We've got police officers walking in and out of the room while it's happening, right? And he's already asked for counsel, correct? He's invoked his right to counsel. He's invoked his right to remain silent.
Yes, sir.
He doesn't have a lawyer, though, right? But he's got a neutral and detached magistrate in front of him. He asks what amounts to a legal question to the magistrate, and the magistrate directs him to whom?
Directs him to Ranger Stoner, Your Honor.
Okay, I mean, that's not a very sterile environment. Is that the best practices, you think, for somebody who's invoked their right to counsel and is asking a legal question of the magistrate to refer them to the police officers as to whom he's invoked his 5th Amendment right?
Your Honor, the state would not argue that that is the best practice in any given case, but the focus here is on who reinitiated contact. And by asking Judge Henry who he could talk to.
Because he followed the advice he got from the magistrate, right? Talk to those police officers.
Well, Your Honor, it wasn't simply that he was
for fair use, we have to stop every once in a while. But this is very, very interesting, and I've always liked this judge right here. I like him a lot. He asks a lot of questions in these appeal cases, and I can see where he's going with this because he's saying, well, had those officers not been in the same room, and then he's asking the magistrate a question, but he still doesn't have legal counsel over here because he's not been given one yet. But then the magistrate says something to ask the police officer. So I can kind of understand now where they're going with, wait a minute. I think maybe he did have a violation right here because he did not have legal counsel to ask, and you can't ask a police officer a legal question. How is that initiating his desire to talk to the police officers when he'd actually asked a legal question? So think about that.
following advice. After Judge Henry had asked if he had any questions, instead of even giving a question, he immediately responds by saying, there were other people arrested. They were telling me. There were other people arrested that were with me. And then he starts asking how they were arrested, and he immediately refers them to John Stoner, who is the Texas Ranger in this case.
Yeah, I guess, I don't want to be too hard on the magistrate here, but the answer was not, you've asked for a lawyer, perhaps you should ask your lawyer. It was, perhaps you should ask the police officers who want to elicit incriminating information from you, and as to who you've invoked your Miranda rights.
That's correct, Mr. Presiding Judge, but I think what's important here is if we look to the Edwards rule and if we look to Valtierra, we need to ask who is asking these questions and whether or not it was police driven. And regardless of what the magistrate had done in response to appellant's questions, Ranger Stoner wasn't there saying, I'm here to answer your questions. He was referred to Ranger Stoner by the magistrate.
It was actually Barron. After the magistrate leaves, the question is there any way you can get them out? And Barron says, and then steps back. Barron says, right now, no. How would I be able to get them out? And then he checks himself and says, wait, I can't ask you any questions. You ask for an attorney, and we'll leave it at that, okay? So it's Barron, and Barron specifically says, how would I wait, I can't ask you any questions. And then he reinitiates. If I tell you what you want to know, will you get them out? They ain't have nothing to do with it. And then again, Barron says, we have to wait for your representation. And it's later, where it says, what if I waive my rights? Is there any way that you can get them out? You know what I'm trying to say? No, absolutely. I can't ask any questions. And then the client says, I'm waiving that right. How is I'm waiving that right? How's that not unequivocal, knowing, intelligent? I'm waiving the right.
Well, Your Honor, in addition to looking at the record support in State's Exhibit 5, which you had just talked about that occurred at 427, a lot of deference, almost total deference, has to go to the findings and fact and conclusions of law that were issued by the trial judge. And at this point, the trial judge, in their findings of fact and conclusions of law, had clearly stated that the appellant was the one that reinitiated contact by his initial question to the magistrate. Even though he is asking subsequent questions about how he can arrange to get
Let me stop you right there. That argument, it seems to me, proves too much. I hear the word magistrate for this purpose. I can't help but hear two words come in front of him: neutral and detached magistrate, right? Isn't that the point of an arraignment? So the neutral and detached magistrate points him to the police officers, right?
Yes, Your Honor.
Is that neutral and detached?
Your Honor, the state can't adequately speak to that because that was not an issue that was presented to this court in the form of appellant's brief. In his brief, he is focusing entirely on how the police were badgering the appellant.
How is that any different? Wait a minute, look. How is that any different if this had happened in a courtroom instead of in an interrogation room? And if the guy had asked, hey, am I going to get lunch? And the magistrate says, well, you'll have to ask the bailiff, or you'll have to ask the guard, or you'll have to ask the ranger that's transporting you. This particular defendant isn't asking about the elements of his offense. He's asking, what about these other people? Can we get them out? So I understand what Judge Schenck is saying here, but to me, it's fairly clear he reinitiates, and I'm trying to see why Judge Schenck has the concerns, and I'm trying to get you to address them on how this is somehow the magistrate inappropriately violating the neutrality by directing him to law enforcement.
Your Honor, I don't believe that simply by asking the appellant if he had any questions, the magistrate at that point didn't know what the appellant would respond to.
I think Judge Schenk's problem is that the magistrate, when he was asked, what about these other people? Magistrate said, well, you'll have to ask that officer.
Oh, wow.
Well, if I
Wow.
can speak for myself, my question was, is there a problem here with a lack of a sterile environment
Yes.
for the magistration?
Yes, there
Why
is.
are the police officers, which is my understanding of their brief and the point it's making, in the room, coming in and out of the room while he's doing the
Yes.
magistration? Why are they there for the magistrate to point to and say, ask them?
Your Honor, I'm not sure exactly why law enforcement was in the room during.
One of them's a witness. He's physically there to witness the waiver of the rights and signs off on the waiver, correct?
I believe so. Yes, Judge Finley. Mr. Presiding Judge, I think the focus here, and I think the way it's been previously described in Pacina and in Montejo, is whether or not it's coercive. And we can see that in the court's findings of fact and conclusions of law, this was not police driven. He acknowledged his rights. He expressly waived them multiple times to Ranger Stoner after being directed to him by Judge Henry. And for that reason, it was not coercion. There were no promises made, and he was not under any kind of duress. And this court should give some deference to the trial court's findings in that matter. If we look at what is going on.
When he was directed to Ranger Stoner, did Stoner re-admonish or warn him again before the questions and answers started?
No, Judge Richardson, he did
And
not.
that is an argument in their brief, correct?
I believe so, yes, Mr. Presiding Judge. However, when we look at this, the officers obviously were in the room, and Judge Henry had previously magistrated him as to both his right to counsel and his right to remain silent. This court, I don't think, would find any harm in the sense that he was immediately magistrated. The officers didn't need to immediately parrot that back to him, Judge Richardson.
I disagree. Stoner verbatim said, so here's the thing. You're going to have to unequivocally tell me that you want to talk to me, that you don't want a lawyer. I don't know how he could have been any clearer.
Your Honor, I'm not.
That is not looking good. That right there, you're going to have an argument because he's going to agree that was improper. I already know he's going to agree it was improper. And you know, when they do these opinions, there's a few of them put out opinions, and there's the dissent. Anyway, and when we get to that, whenever it's put out, of course we're going to read it. We're going to bring it out, but it hasn't been. The opinion has not been done yet. But yeah, I can see I know where he's going. Goodness gracious.
Not exactly understanding your question. I'm sorry.
I'm just commenting. I think the question was, did Stoner again say, hey, you've got an attorney, I can't talk to her? And there's 3 instances here where Stoner specifically says, you've requested an attorney, I can't talk to you. You have to unequivocally say. I mean, Stoner did tell him several times.
Well, Judge Finley, that goes more to waiver than the actual recitations of his rights, I believe, under
But
3823.
at this point in time, he's already signed a written waiver of those rights after having them expressly read to him by the magistrate.
Yes, Your Honor, I do believe that's correct, Judge Finley. When we looked at the totality of the circumstances, the appellant asked to talk, he waived his rights, and he confessed. Because the trial court has discretion and is granted almost total deference when given findings of fact and conclusions of law, in summary, these were not commitments questions. These were improper commitment questions, not proper bias inquiries. And as to issues 5 and 6, he reinitiated contact, he waived his rights, and he spoke. And for that reason, we ask the court to affirm his conviction and death sentence. Thank you.
Mr. Gill?
So with regard to the Fifth Amendment waiver issue, the burden of proof is on the state to establish that there was a valid waiver. Going to the issue of whether or not this was a sterile environment, it certainly was not. Not only was the police officer still in the room when the magistration occurred, but it's apparent from the context of the record that the police officers were responsible for even bringing the magistrate there. They began talking in the beginning after Elders originally invoked his rights, that we're going to go get a magistrate and bring a magistrate in here and have you magistrated.
Doesn't that show that their intent was not to violate his rights? And also, what rule is there that prohibits the police officer from being there as a witness?
There is not a rule specifically that prohibits a police officer from being there. The rule is, the rule that I'm relying on is a rule that keeps police officers from continuing to discuss the matter with the defendant after he has invoked his right to counsel.
But that's different than a sterile environment that you were discussing.
The sterile environment goes to the fact that the police officers were there and had the opportunity and took the opportunity to keep talking to him about the case when he
But
had.
they were
Hey there, nice to see you, Frightening Badger. Thank you for coming in. I hope you're enjoying this because this is my favorite part, is when they have oral arguments. Thank you.
the ones that wanted to make sure he was magistrated. So that seems to deny or be counter to what you're saying in terms of their interference. I don't see bad, their behavior seemed to be that they wanted to get a magistrate. They wanted the guy to be read his rights, and they were not going to talk to him until that happened.
And I see that in the record. I also see in the record the fact that they wanted him to talk and wanted him to confess to this series of facts.
Well, let me jump you forward there. He did eventually confess about as clearly as you can in this conversation that resulted, right?
He did.
Talk to me about harm. Assume that there's some problem under the Fifth or the Sixth Amendment with the police officers hovering around to be in a position to catch him when you ask this question to the magistrate. Why is it reversible error?
Because this confession went to not only the case that he was on trial for, but also all of the punishment issues that we face at the punishment phase of the trial. When we talk about the fact that he was on trial for a discrete set of issues at the first phase of the trial, that being the killing of the basically innocent bystander, the woman that was killed during the flight from the shooting of the police officer. But then we talk about whether or not he's a future danger and whether or not there's any mitigation at the punishment phase of the trial. And we've got the shooting of a police officer to deal with at that point. So this was a very, very painful and difficult confession to watch because it was so comprehensive and went so deeply to all the facts of the case that we faced at both phases. So this was a tough one. This was an issue that the police were able to get the confession out of him, and they won the day on that. They got a very comprehensive and very hurtful confession.
But how would it have affected the result? I mean, was identity genuinely was in dispute in this case? Was the who pulled the trigger seriously in dispute here?
No, I don't believe it was. I don't believe identity was ever an issue.
He was on video shooting the officer.
He was on video.
He left his tax documents, including his social security number, in the vehicle that was on the video, officer's body camera and police vehicle.
Yes.
That's the one the shots came out of.
Yes.
He was in a vehicle that drove into the police impound lot and then effectively executed someone at the police station.
Yes.
When he confessed, and Judge Shank is correct, but when he confessed, among them, he said, "I'm busted red-handed, man."
And he was caught in the same
even
vehicle.
Assuming this confession was tainted, is it your argument that he would not have been convicted?
We have two issues here. Would he have been convicted? Number one. Number two, would he have received the death penalty? And when we look back at the questioning.
Okay, let me just say this. The problem that he was not even on trial for shooting the police officer. Let's remember, he was on trial for shooting Miss Patricia Waddell in the commission of a robbery. And that is why he's on the death penalty. Has nothing to do with shooting the officer. So I don't understand why this appellate attorney just keeps going on about that, because he's clearly pissing off the judges. But we'll let him keep talking. Here we go.
The failure to allow the proper questions in the case. Death penalty cases are treated a little bit differently.
Okay, and I agree. I guess my question is something like this. Given all the other evidence in this case, is there anything that came out in his confessions? Is there any additional piece of information? Is there any lack of remorse or characteristic that could have had a significant impact on the jury?
I believe what came out in the confession that we didn't hear from any other source was his basic motivation for shooting Officer Lott.
The thefts of the catalytic converters that he thought he was being persecuted for.
That he just didn't like police officers, and he was going to shoot one.
Whoa.
And that was hard to overcome.
You don't think that's a dangerous individual who should be taken off the streets? Absolutely should. I don't like police officers, so I'm just going to shoot one, and he does? No. He wasn't even charged with it, but he did it, and because he wanted to, he's a monster. But let's keep going.
With the punishment phase, obviously we didn't. That was a tough act. That was a tough stance for him to take in a law enforcement oriented community like Johnson County. Thank you very much for your time.
Okay.
Further questions? No. Thank you, counsel, very much. This case will now be taken under submission.
Thank you, Judge.
All right.
Unless I see urgence otherwise, I think we will stay.
Okay, so that is the end of the, let me turn these off. Hang on just a second, and we'll start talking for just a minute. All right, so that was the end of the oral arguments. Now, next steps for this case is going to be that the panel or the chief judge assigns one judge to write the actual opinion. That's going to happen next, okay? So, you know, if, going down here, hang on a second. And they have, like, there's really not a time limit for them to kind of do this. You know, it can take 3 or 4 months. It's really not just a time limit for this to happen. But and then they'll have, like, other judges may plan concurring opinions or agree with results, or there could be a dissenting opinion, which is a disagreement entirely of the chief judge's decision. Okay, so they're going to draft their opinion. They'll circulate it amongst the panel of judges, and then they'll say, hey, do we need to make edits or changes or whatever? And then they'll vote. At some point, they'll vote on it, and then the final decision will either be affirmed or reversed and conviction overturned, or it could be remanded and sent back to the trial court for further action. Now, there are post-decision motions that happen in these cases. The losing side can file a motion for rehearing or request an in-bank review, which all judges of the court reconsider. So deadlines are usually short when they want to file the in-bank review. Sometimes it goes up to the higher court for review. If they're still unhappy, they'll petition for a discretionary review or go to the federal Supreme Court. So that is what's going to happen after the oral arguments. But I'm going to watch out for this, and as soon as the opinion comes out, we're going to come back on and discuss the opinion. This case is, I think it's shocking that they did not even charge him with shooting the police officer. I know the police officer lived, but he still is. Imagine a person living next to you, walking beside you in your neighborhood that says, I don't even like police officers, I'm just going to shoot one. Well, what happens when they don't like the sound of your dog barking? Are they going to shoot that too? That's a very dangerous individual. But anyway, so that is the case of Jerry Don Elders and his oral arguments in the front of the Texas Criminal Court. So I'm going to get off of here for the day. Thank you for coming in. As always, I appreciate seeing everybody. Please hit that like button on your way in or your way out, whichever one you want to do. We're really working to kind of get our channel growing again. We kind of had some little missteps, but that's okay. You know, everybody makes mistakes. We talk about our mistakes and we move forward. That's how life goes. So thank you. Have a good afternoon. I'll see you probably tomorrow. I'm going to come live again tomorrow, and we'll talk about a different case tomorrow. But be safe. Take care of yourself. Go hug your babies. Life is short, and your time with them is even shorter. So I'll see you tomorrow. Bye, guys. Thank you again.